SJC-10592, Commonwealth versus Holbrook.
Mr. Kelly, good morning.
Good morning, Your Honors. If it pleases the court, my name is Brian Kelly. I'm representing the appellant, Richard Holbrook, Jr. Your Honor, this is probably the longest brief I've ever put forth. Usually when they teach us how to do briefs, they always tell us two or three issues. This one I couldn't limit. And I would hope that at least I got across to the panel that there were numerous ineffective assistance of counsel which completely prejudiced Mr. Holbrook from being able to get a fair trial from a lack of preparation on behalf of the trial counsel to inadequate presentation, and then followed up, of course, by a few issues regarding prosecutorial misconduct and a couple of judicial errors.
Are you claiming that first appellate counsel was also ineffective?
Yes, Your Honor, we did. We did in the second motion for new trial because in fact, I have an affidavit. I have affidavits from both trial counsel and appellate counsel where they basically admitted that they missed a few things. But the brief more or less concentrates on trial counsel's errors, mostly in the fact that trial counsel never prepared for this case. This was a case in which he never bothered to find out what Commonwealth's discovery was. He was given this the technical report regarding a computer found in the victim's bathtub, and yet didn't know throughout, or claimed he didn't know throughout the trial, that they were able to recover the data that was on the submerged computer.
Do you know what data the Commonwealth recovered?
No. To this day, I do not know what the Commonwealth recovered.
Okay.
The reason...
Go ahead.
Oh, thank you, Your Honor. The reason I say that emphatically was, and again, this is, I don't know computers personally, but taking both the prosecutor's statement to the court and the Commonwealth's expert, Mr. Perry, he claimed that he had the ability to go in, after the data had been recovered from the Secret Service, he had the ability to go in and retrieve the emails, both from the victim to...
Who claimed this?
I'm sorry?
Who claimed this?
The Commonwealth's expert, Mr. Perry.
And that was this is a trial, he said this?
He said it right in trial, Your Honor, as did the prosecutor told that to the judge, that we had the ability to get everything off the computer, and he specifically said incoming and outgoing emails.
But who said it was not of evidentiary value?
That is debatable whether that was actually said, Your Honor.
The judge just believed
the judge didn't believe that was said.
Okay.
According to defense counsel, he claimed that in a pretrial motion, he came in and asked one of the prosecutors, was there anything helpful? Did you find anything on the computer? And the prosecutor allegedly told him that nothing of evidentiary value.
Can I talk to you about the emails, though?
Yes.
Do we know, even if these are emails from the third party, whatever you call them, AOL, and what is it, AOL and Yahoo, is it? And Manhunt or something like it. Do we know if these emails we're talking about are from November 2006, right?
Yes.
Do we know if they're still even available?
I do not know that, Your Honor.
So this is what you want, though?
Well, what my point was, and this is where hopefully I've showed the prejudice in him not getting, defense counsel not getting these emails at the time, was all I can go on first is the representation by the Commonwealth's own expert and the prosecutor that the emails were available to be gotten off that computer. Subsequent to that, Your Honor, when I jumped into the case, I filed the second motion for new trial. I was able to retain an expert
Yeah, and
who
he-
came in,
and he-
and he could not find any emails from the, coming into the victim.
But the thing was, when I look at what was presented to Judge Chin in the motion for new trial, I don't know that it was ever really made clear to Judge Chin that the ones that were recovered by the computer expert were from November late 2005, but you're looking for ones for 2006, a year later. So it doesn't matter if the ones that you recovered were hostile or not, because they weren't really relevant to the time period.
You're right. And what I kept trying to explain to Judge Chin, because it kept getting repeated back to me by both Judge Chin and the Commonwealth, is, well, the emails that went out from the victim to this third-party, potential third-party culprit weren't hostile. And I wholeheartedly agreed
But they
with,
were not timely. I mean, they weren't related to the event either. The death was in November of 2006. Why were we talking about emails from 2005?
exactly. And
I don't think that was made clear to
I
the
told the
judge.
judge, Your Honor, that he was absolutely right. They were not relevant to what I was trying to find.
No, but I don't think that it was ever pointed out about the time difference.
You're right.
It took a while to figure that out.
But I'm just figuring that out now as you're telling me, Your Honor. I did not look at that either.
Okay, so,
But my point to the judge was that telling us that the emails from the victim, Mr. Auger, to Mr. Meager were not hostile was what I wholeheartedly agreed with the judge. I said, they're absolutely not. First appellate counsel kept trying to make that argument, and I said, that was not an argument that holds water. This was a person, the victim was, as I think I stated to Judge Chin, was pining away for this other man. What was alleged by Mr. Anderson
was a good friend of,
was a friend, yeah, and who spoke to the victim the night before he was killed.
spoke to the police the day after the.
Yes, Your Honor. He said, look at the emails from this kid named Sean, who is Mr. Meager. He's been emailing, according to the victim, he's been emailing him constantly and extorting him. That's what I was trying to find out. The emails from Mr. Auger, the victim, to Mr. Meager were irrelevant. It's like an unrequited relationship there. The victim's emails didn't make any difference. He wasn't hostile. He wanted the other man back. Mr. Meager was the one who we have the alleged emails from, and we can't get them.
Because you don't even know if they exist.
All I can tell you, Your Honor, is
Have you asked AOL or the other email service providers whether they retain records for this long?
did not do that, Your Honor. They were not allowed. They were never allowed. They were requested from in a motion, a Rule 17 motion for.
Post-conviction discovery.
Yes, Your Honor, and the judge denied that.
I understand that, but I'm just saying, and you're saying that was error, because you really want them? I mean, if you couldn't get them in 2015, what makes you think that they're existing in 2018? If you couldn't, you don't even know if they existed in 2015.
Your Honor, you're absolutely right. I do not know that. All I can tell you, Your Honor, is, and I equate this to that Connolly case with if the knife isn't in existence anymore, he should be able to get a chance and at least explain to a new jury that there was evidence before. All I can go by is the Commonwealth themselves, through their own expert and their prosecutor, specifically explained to the jury and the judge that they could have gotten all the emails, especially the incoming emails, to the victim. As I stand before you, Your Honor, I can't tell you if that can be done. I don't know. I'm not that computer savvy. But I'm relying, Your Honor, on the representation that was made by both the prosecutor and the expert, who said, we can find it. Now we can't. Now, does that mean it went out of existence, like you seem to be suggesting, Your Honor? It could be. I don't know. If it did, that's a bigger prejudice, the fact that we could have gotten these.
But it's still speculative until you actually lay hands on these emails about what's in them. How do you know that they were hostile?
All I can go,
From Anderson, and do you have an affidavit from Anderson?
we don't, Your Honor. And that became a question, which if I could for a moment just address, in that the judge made mention that there was, that when they brought the first motion for new trial, they didn't bring an affidavit from Anderson. However, Your Honor, I would suggest to you, okay, that unlike if it was someone that the defense counsel had dug up and said, I've got a witness who's going to come in and tell us this was a witness that was brought in, was interviewed by the police, and the statement was given over by the prosecution. I would suggest that the reliability of taking the Commonwealth's witness, Commonwealth's discovery, would be much more beneficial than if it was just, oh, we grabbed some Tom, Dick, and Harry off the street who's going to come in and tell us that, but we're not going to give you an affidavit. I would think the reliability, Your Honor, as to that witness would obviate the need to actually have an affidavit.
How about Williams? No affidavit from him either.
No, they don't have an affidavit. Oh, yes, there was an affidavit, sorry. There was an affidavit, I believe, from the Commonwealth, had an affidavit from Williams,
As saying what?
that he was going to come in and testify.
About?
Well, I don't know as he said what he was going to testify to. However, it did come out in testimony as to that he told the, I believe it was Detective Cummings, that he saw Sean.
And he was a retired police officer, so he would have tremendous credibility.
That's correct. And
Affidavit
defense
from the
counsel never brings him.
No, but we don't know what he's going to, you know, he said that apparently at the time, but I mean, how do we know who he's going to testify to that?
I can't tell you that, Your Honor. I don't know.
In fact, he showed up and the trial counsel.
He showed up.
trial counsel
He did,
decided
in
not
his
to.
affidavit, he said he showed up. I believe he said he was ready to testify, and defense counsel sent him away.
Yeah, we don't know why.
That we don't know why, and that's one of the unexplained ineffective assistance of counsel. If you have a,
You have an affidavit from that counsel, but you don't have an explanation from that counsel as to why.
no, he didn't explain why. He just said, well, he did say because he found out, which this makes no sense to me, but I'll tell you what he said. He said because he found out that there were, nothing could be found on the computer, he decided not to call Williams. That logic evades me, Your Honor, but that's what his explanation was.
Now, the judge would not allow Anderson to testify.
Correct. And one of the things that happened at that point is when defense counsel gave an offer of proof, the judge asked, how do you get around the hearsay?
Yep.
Defense counsel gave a very poor, I think, explanation or rationale, saying it went to the victim's state of mind.
What did it go to?
Should have gone to a Bowden defense, in the fact that which eliminates the hearsay portion of it right then and there, Your Honor. I mean, if the police were told, okay, that you got to check these emails out, and I will just take a quick aside, Your Honor. One of the things that the judge says is, well, that's speculative. If I would agree with the trial judge that it would be speculative if we just had Mr. Anderson just saying that. You got to check his emails. I mean, I'm sure police get all sorts of leads. But juxtaposed to having just heard, you ought to check the victim's emails, and then the CSS team comes in and finds the gentleman's computer submerged in a bathtub full of water, would seem to me that you put two and two together, maybe that leans some credibility. I'm sorry, yes, Your Honor?
There's a camera on that computer, right?
That's correct.
So the person may be throwing the computer into the water because he's worried that the camera may have been on.
That would be my, and again, I don't know much about, I can't tell you, but apparently water doesn't damage a
Does
computer. I
Mr.
didn't know that.
Meager look anything like the defendant? Because we have at least how
No.
many, 2 or 3 witnesses seeing this man with this Carhartt jacket, scruffy looking, going into the victim's car. Victim doesn't let anyone use his car, right?
According to testimony, I know things, but I can't tell you, Your Honor, because it's
Excuse me?
not. I said, I know things from talking to the client, but I can't tell you because it's not evidence.
Yeah, I'm just relying on the record. But we have the victim's mother seeing somebody going into the guy's car. Mr. Meager, what is the physical description of Mr. Meager?
Mr. Meager, I believe, is shorter and a little stockier.
And does the mother know Mr. Meager?
Yes.
And does Mr. Humphrey know Mrs. Meager as well?
He does, and initially, he actually gave police a statement that he believed that it might have been Meager, but then he retracted that.
Okay. All right.
The bad teeth were something that everybody noted about. this
Right.
man. Tall
Yes,
and the bad teeth.
Well,
Scruffy, Carhartt jacket.
yeah, the other thing, Your Honor, is that there's much talk about a scruffy, thin man. However, we're not necessarily saying that the person that walked through the door the day of the murder, who the victim said, "Did your girlfriend throw you out? Did you stay with your friend up the street?" We don't know if that was the murderer. We don't know. We just know that was a man that Mr. McDonald, the guy that buys the marijuana from him every 2 weeks, said, "I saw somebody come to the door." The description, though, of the salutation by Mr. Auger, the victim, didn't fit the defendant, because he said, "Did your girlfriend throw you out, and did you stay with your friend up the street?" In fact, he didn't have he had a girlfriend who passed away, and according to the testimony of people that knew him, he doesn't have a girlfriend in his life, and he doesn't stay with anybody up the street. In fact, the other gentleman, Mr. Humphreys, who came down the street to stop in, and just uncharacteristically saw somebody else, so he clearly went away. He stayed up the street with a friend. I mean, the description seems to hit him more than it does to the defendant.
So what do we do with all this? Okay, you have a theory which says that you've got Anderson who says to the police you should look at the emails from Meager to the victim, and then you've got Williams arguably saying that he saw Meager at the house the day before the killing, and Meager says no, that Meager and his girlfriend says no, that never happened. And you have all these emails which you say arguably could corroborate it, but but you don't have any information that they indeed would corroborate it. So even if you say the counsel was ineffective, how can you show that there's actual prejudice if we don't know what would have been shown to the jury had he been effective?
The point that I'm trying to make, Your Honor, is that we don't know what we don't know, because because of the complete lack of investigating anything on the part of defense counsel, there are still open questions.
But the failure to investigate also requires a showing of prejudice. I mean, you got a potential third-party culprit, you got a Bowden issue, and the failure to investigate, which feeds into that. But you got to still show substantial likelihood.
Exactly, Your Honor. And that was, I keep doing that, I'm sorry. Then that was the point that I tried to make in the motion for new trial, is all I can go on, as I said, it's not gospel according to Brian Kelly here, because I don't know anything about computers. All I'm going over is both the Commonwealth's expert and the prosecution specifically told both the jury who made the decision and the judge that we could have gotten emails incoming off the computer, and then they made,
Transcript reference for that, please.
I'm sorry, Your Honor?
Transcript reference for that.
The transcript, I can get it for,
appreciate
I'll put it in a 16L letter for you, Your Honor. I can't pull it right now, but it definitely is there.
Okay. Could I ask you a question?
Yes, Your
I
Honor.
don't even know what time this man died. Do we have a time of death for him?
No, we have an approximation was the last time he was seen, and then no communication. But
Medical examiner did an autopsy?
he did, but they did not give a,
Time of death?
no, Your Honor.
So we don't even really know what time of day it was or night. We think it was Sunday?
We do, the only thing that we have, Your Honor, is that when Mr. McDonald, the drug client, came in and supposedly saw a man, he was apparently the last person that saw him, the victim alive, and then the computer was unplugged, according to the Commonwealth's expert, at like somewhere between 12:30 and 1 o'clock in the afternoon.
Sunday.
Now, yes, I would, and again, I guess we could speculate in that case that he was probably dead when they pulled the computer out and threw it in the bathtub.
And do we know what time it was that Mr. McDonald saw him?
Somewhere in the noonish, 11 to noonish area. So it seemed like there was a window. I could actually probably give you the exact times from the transcript, Your Honor.
And Mr. Meager was there or not seen, did anybody seem to say it was him? Was
No one
Meager?
saw him that day, but the fact that Mr. Williams was going to come in and tell the court that he saw him the day before does two things. One, it knocks out the alibi that he and his girlfriend, Anna Sawyer, were up in Littleton for the entire weekend. And the other statement that Meager made, that he had last seen the victim on October 18th, 2006, which was a month prior.
So nobody saw, I'm sorry,
Go ahead.
nobody saw Mr. Meager the day of, but a lot of people saw somebody with a Carhartt jacket and bad teeth.
One person saw the Carhartt jacket that day. Everyone else sees him along the lines of we saw him coming down the street. One person, one of the neighbors said he's seen him before, but he couldn't tell you if it was that weekend.
I thought McDonald, there's a person there when they're doing a drug.
That's the drug dealer, Mr. McDonald, George McDonald.
He sees him, then doesn't the mother,
Mother sees it, yeah, I'm sorry, that's
Doesn't
correct. She
Mr.
sees someone with a Carhartt jacket.
and isn't there a third person, Mr. Humphrey, doesn't he see him that day?
He sees someone, but he goes to the police and cannot identify.
But doesn't he identify the jacket?
He does identify a
You
jacket.
got three people
Apparently,
identified.
yeah, I don't even know what a Carhartt jacket is, but from everybody talking about it, it's supposed to be some popular jacket that they wear. And apparently, there were three of them introduced into evidence.
And is there any evidence as to an alternative explanation for why he was so flush with money after the killing?
Yes, Your Honor, absolutely. Thank you.
He got paid by half, he got
He,
$300.
his boss, Mr. Randall, has been telling him that he has been working, he works sporadically, but he had been working for him as doing construction or roofing, whatever it was, for the past 6 weeks. He gets paid $300 a day, and he'd been doing that for 6 weeks prior to that daily, so he was pulling in $1,500 a week. So he had plenty of money.
But I thought he said he only paid him $300.
He paid him $300 for the day before Thanksgiving. He worked a half a day before Thanksgiving, and he paid him $300 for that day. That was what he was trying to pay him back. But he had been making that money, and he'd been consistently working there for the prior 5 to 6 weeks.
But did Mr. Randall ever testify that he in fact paid him that amount of money? I thought Mr. Randall was saying that he didn't have the opportunity or didn't have the means to pay, and that's why he was scrambling
But
to
he
get
didn't
loans
have the
from
means
people.
to pay him the last day. He owed him $600, he had paid him $300, and he was going around trying to find
Well, he never testified that he actually handed it over.
the payment that when they all went around trying to find his mother, he did not make that payment.
What would have made him flush? Enough to pay the hotel $300?
For the past 6 weeks, he's making $300 a day.
I know he may be making it, but he wasn't given the money.
Well, Your Honor, what I would suggest to you is that if the day that the boss, Randall, and the defendant are going around trying to find $300, that was only to pay the last $300. He had paid him, he had worked, he had paid him for that week only half. He paid him $300, he owed him $300, he was trying to pay the rest.
But did Randall testify that over the course of the last month, I had paid him $3,000?
He did not, Your Honor. The only thing I can tell you is he was trying to pay him the last $300 that he owed him. He was making $300 a day, and he worked for 5 to 6 weeks.
Okay, thank you.
I'll rest on the brief. Thank you, Your Honors.
Ms. Burbine, good morning.
May it please the Court, Carolyn Burbine for the Commonwealth. The defendant's entire claim is based on this desire to get emails as a result of Mr. Anderson's interview with Detective Cummings. We don't have an affidavit from Mr. Anderson.
We do have the police report, though.
We do, but we don't have an affidavit from him, and Judge Chin appropriately found that as a result, it's conspicuously absent.
Could I ask you a question? I'm sure
yes.
it's not going to surprise you. What emails did the Commonwealth recover from the computer by the time of trial?
I don't know. None of that heat report doesn't say anything about recovering emails.
And you have not investigated with your trial counsel what emails were in existence?
If you look at our prosecutor's affidavit, she said the Commonwealth's concern was the webcam and the
Time,
the time of the, I'm sorry, yes, the time of the hard shutdown. And that was what she understood was the purpose of the examination.
But what about the examiners who actually said that, testified at trial according to counsel, that in fact the computer could have had all kinds of emails, including the incoming emails that they...
I have to look at his statements again, but the heat report said, and what I believe his affidavit said and his testimony was that he only looked at the his job was to look at the hard shutdown and the web camera.
But he was testifying
And he
also
did-
to what Ms. Marina.
And he did speak to Marino, who had
Marino, I'm
examined
sorry.
it before him, and she's the one that told him there was no information of evidentiary value. That was the source.
But where was this coming from that they had the emails that were incoming? They had all these emails.
I'm going to have to go back and check. I believe that defense counsel may have asked him, were there emails? And I think he may have said there were, but I didn't look at them. And I think maybe defense counsel said, so you didn't know,
Do we know?
you don't really know what's on that computer? And he said, no, I don't.
I'm
So it
sorry.
was something like that.
Do we know whether at the time that the defendant was asking for those emails post conviction discovery, do we know if the Commonwealth actually had emails that it could give over?
No, I'm not aware of Marino doing a report. I haven't looked in any boxes. I just went by the heat report and that and the Commonwealth's affidavit, which was we were focused on the webcam, we were focused on the shutdown.
Okay, focused on doesn't mean you didn't have them.
But Judge Chin found no prosecutorial misconduct.
I know,
and
I'm not suggesting misconduct, I'm just trying
I don't know if, I have no knowledge of any report by Marino being sent to our office. The only one I'm aware of is this heat report, and that's all that the defense has presented on this motion for new trial.
So the Commonwealth didn't resist this by saying, we don't even have anything to give over?
I don't recall anyone saying that, no.
And they resisted having AOL or anyone else give it over? I don't understand what the harm would have been.
I don't know that we did anything beyond, I'm not sure what Marino did. I don't know what she was asked to do. I don't know what she did. I don't know what she found. And I don't even know if I have to look at what Perry said again. I do recall him saying that that Marino had told him there was no information of evidentiary value.
So you send the computer to San Diego to be investigated by Secret Service. And they don't look at the hard disk to see what documents they can retrieve?
It said that
They don't look for emails?
I believe that the Secret Service imaged the hard drive, and they sent it back to the Sheriff's Department. And then Marino looked at it
So I'm sure Marino is with whom?
with the Sheriff's Department, and then
They did image the hard
it
drive.
did image the hard drive, and that is in the heat report.
Okay.
Marino examined it. That's what the heat report says.
Who was Marino again? He's with the sheriff?
She's with the sheriff's department.
And is she an expert?
I'm assuming, but I shouldn't even assume. I don't know. That's what, in the heat report, it says that she examined it. I think she is an analyst. I think I called her, I think we called her an analyst.
With the sheriff's department? Not with
Analyst, it's in the I think it's the computer analysis.
But not with state police?
I want to say sheriff's department. I'd have to go back.
Sheriff's department is investigating a murder?
It may be because what the computer, I think it's a computer analysis team. They may be a part of the state police, but I thought someone said there was some reference to sheriff's department. Do you want me to pull it out of the record?
Well, you could do it in 16L, but, so, you've got an investigative report from Anderson, which says, look at the emails, and nobody does?
We have no affidavit from Anderson, which was a weakness
But
that
he spoke to the police.
he spoke to the police,
And he
but
said-
we don't know his basis of knowledge. We don't know,
Nobody investigated it either, it looks like.
well, the heat report was turned over to defense counsel. Defense counsel did get an expert.
Who couldn't,
Looking at the
at that point, who could only get out like 4 from a year before that were absolutely irrelevant.
Well, they I mean, I'm guessing that the defendant's expert pulled everything that he could off there, not just,
Yes, that's right, but that was sometime
right.
afterwards.
And the emails that have to do with, right, the emails that have to do with Meager only go through the beginning of '06.
And he was
And
killed
none
at
of
the end
them are
06.
incoming, they're all outgoing.
He was killed at the end of '06, right?
Yes, November of '06.
So the emails that the expert was able to get out were only from
Only
'05.
through, right.
Yeah.
I think there were might have been a couple into March of '06, but they were to other people talking about Sean, not to Sean. You're right. I think the ones that actually were from the victim to Sean were '06. Maybe January was the last one.
And what did the defense
05.
counsel expert get? Did he get the image of the hard drive that had been done by the Secret Service in San Diego?
From his affidavit, it looks like he did, and that he did his own analysis, and, you know, and those were the emails that he made Judge Chen aware of.
What was it that he was allowed to examine the same hard drive that the Commonwealth was able to?
I'm assuming that he did, Your Honor. I believe it was turned over. I can't remember if the defendant's brief says exactly that. I think it does. I mean, I don't think there's never been a claim that they didn't get what we had,
Okay.
or that somehow we dropped the ball that way. I mean, I have, from everything I've read on these motions to retrial,
But then I don't understand how they can only extract. from
I don't
05.
either. That's why I'm wondering if Perry was mistaken on, he didn't look, it's clear from Perry's testimony and his updates, he was not analyzing those emails. He's just going by what Marino would have told him, and we don't know what she saw.
So what do we do with this somewhat astonishing lack of investigative curiosity?
Well, I would say that it all comes down to substantial likelihood of a miscarriage of justice. Would the error have influenced the jury's conclusion? And Judge Chin did the analysis. Bowden, third-party culprit, he did a very thorough job. He was the trial judge. He knew the evidence. He makes the credibility determinations. And he concluded that they have the hard drive now, and they have not produced anything that would have influenced the jury's conclusion. You can kind of get in the weeds here with these claims, and what you need to do is go back and look at what evidence did we have.
What
And
evidence
Sean
did you
Meager
have?
testified.
What evidence did you have? I mean, you had no forensic evidence of any kind. The fingerprints that were found, the fingerprint that was found on the wallet was not either the victim's or the defendant's. The palm print was not either the fingerprint, it was not either the victim or the defendant. And I think there was DNA found, and it was not of the victim or the defendant. And no investigation was done of whose it was. There was nothing to try to even figure out if it was Sean's.
What we do have is the defendant he's raking leaves 2 days before the murder. We have video surveillance from Mr. Parada of the defendant walking to the defendant's house to rake, and we have
That was
what
2
he's
days
wearing.
before. Wasn't that 2 days before?
Yes, but we have what he's wearing, and we have the way he walks, and we have the way he looks. 2 days later, McDonald says that he sees someone, and it's tall, skinny, scruffy, Carhartt jacket, sweatshirt. It's what the people raking who know the defendant by name described him as wearing. And we have surveillance from Parada again on that day of him approaching the victim's house. And the jury could look at that and say, ooh, do we think that's the same clothing? Do we think that's the same build? Do we think that's the same gait? And then we have we have McDonald, who saw him in the kitchen, tall, skinny, scruffy, bad teeth.
But he couldn't
And that
identify
was
the
it.
defendant. He couldn't identify the defendant from a photo array.
He did from, the first photo array had a picture of Meager, and he didn't identify Meager. Second photo array had a picture of the defendant, and he said, ooh, number 3 looks like him, but he needs to be more scruffy.
50% sure.
Then they gave him another one with an updated photo of the defendant, and he said that was him. So again, so we have McDonald. Then McDonald leaves around noon. There's a hard shutdown at his brother, the victim's brother talked to him at noon, Weatherby talked to him at noon. 12:30, there's the hard shutdown of the computer, and by 1 o'clock, 10 of 1 or 1 o'clock, the truck is being driven out of the driveway to
And the mother
Stop Shop.
sees.
The mother and Humphreys see him, and they know, and they describe Carhartt Jack, the whole thing.
And they know Meager, it's
And
not
they know Meager, and it's not Meager, and they say it's not Meager. And then, so we have the truck to the Stop and Shop. And then we have a man going into the Stop and Shop, Carhartt jacket, skinny, bad teeth, 30.
But the grocery clerk cannot
Grocery clerk,
identify him.
no, but it's a grocery clerk who has spent how much time with him, handed him money. But he did have the description, and we have what he's wearing. Then we have the truck to the parking lot, where it's left, and a figure getting out. And the jury can see all of these photos, see what that person is wearing, see what he looks like. Not good pictures of face in the surveillance, but again,
We also have testimony that he always wears the same clothing, right?
the brother said he always wears the same clothing. And everyone describes him the same way, tall, skinny, and the bad teeth are consistent, and we presented photographs of his mouth. We have him going to his, he buys the cell phone, he pulls out a 3-inch wad of cash. This is a guy who, on the 2 days before the murder, was telling Bob, my boss owes me money, I'm not getting paid until Monday. He tells, I may have it flipped, and he tells Weatherby, I'm getting paid tomorrow. So and I came here to rake because I met the victim at the donut shop, and he said if I wanted to make a few dollars, I could come and rake. So he needs money, and he's bumming cigarettes off Bob when he says this. And then all of a sudden, he has a 3-inch wad of cash. His boss picks him up. He doesn't have the jacket anymore. Boss says, where's the jacket? And the boss had given him the jacket. Oh, I left it at Steve's. You want to go back and get it? No. So now he's not wearing the jacket anymore. He's buying cell phone at Cumberland Farms.
Could I ask you about the cell phone, the timeline of that? Because from your brief, it looks like the police found the packaging from a cell phone, and then a few hours later, the defendant was seen buying one. I don't understand that.
I'll have to check that. I'll have to do a 16L on that. I'll have to look at that. I may have put
Thanks.
the dates or times wrong.
Okay.
When the boss pays him one $300 increment, how many days before the murder is that?
I don't know if he talks about, I don't know if we know exactly when he paid it. I believe that,
And is that before or after he says he's broke?
He has been paid $300 before. My recollection is he's been paid $300. I don't know when, before he says he's broke. And he says that his boss owes him another $300. The day of the murder, the boss picks him, no, or the next day, the boss picks him up, and they drive around trying to get him the $300 from the boss's sister, from the boss's mother. They can't. And yet he has this wad of cash. So, and the clerk described it as hundreds, 50s, 20s, 3 inches thick.
How do we know, though, that
And
it
he's
came
bought
from
new
the-
clothes.
that it came from the victim? Was there testimony that the victim usually kept a lot of money in the house?
Yes, he was, they found a big plastic jug in the
So that was
truck.
coins,
Which
right?
was we asked the jury to infer that was the coins. But the victim owned a car detailing shop, and was often paid in cash. And he sold marijuana to his friends on the side, and his brother testified that he, a few people testified he always had between hundreds and thousands of dollars on him at a given time. And he didn't keep it in a wallet, he kept it in his pockets. And when they examined his pants, there were cut marks on the pant pockets.
It's really hard with a Bowden defense. The defendant's position is the Bowden defense is obvious. And it looks like you want to contest that, you're welcome to. But it's really hard to sort of, that's a Bowden defense goes with case hasn't been proven beyond a reasonable doubt to the jury in closing argument, usually along with something else. And so it's very hard to gauge the implications of not pursuing even an obvious Bowden defense.
Well, I would argue that the whole linchpin of the defendant's closing argument was a shoddy investigation. The police just decided it was the defendant. Once they did, they wouldn't back off it. And again, the whole Bowden defense is based on Anderson, no affidavit. And Judge Chin made that finding. We just have the police report. And Bowden, I mean, his whole
What did the
cross.
investigation, though? I mean,
I'm sorry,
you said, why do you need an affidavit then, if you've got the
Well,
police
the
report?
whole
Because
the whole
it would be the
Bowden.
police not following up on what was given them, and
Right.
that doesn't matter if it was an affidavit. It was a question of whether or not they followed up on the affidavit.
But a
I'm
lot
sorry,
of,
on the police
but a
report.
lot of what the complaint is that they didn't follow up on these emails.
Or that.
So, which would, and the whole source of the information that they were emails was Anderson, and we have no affidavit from Anderson.
No, but we do have a police report that the police did
we
not
do.
follow up on, and that would
We
be,
do.
that would go to Bowden defense.
So the claim is the police didn't follow up on the tips about Sean Meager. So even if you look at what Anderson told them, oh, it's this kid, maybe you should look into this kid, Sean Meager. Well, the testimony from the police was, we did. By the next day, they're at Meager's house. They were interviewing him and his girlfriend separately.
Meager's girlfriend?
Meager's girlfriend, yes. They interviewed them separately. He had an alibi,
That he was home all weekend.
and he said he was home all weekend.
But the police officers saw him on Saturday.
Well, we don't have testimony to that. We have an affidavit from Williams that he believed he saw, I think it's a guy named, the boy named Sean the day before, but we have no testimony to that.
More.
And we don't have any details. How well does he know Sean? When did he see Sean?
Did they follow up with Williams?
Did the police?
Yep. Go to a retired police officer and ask him?
I don't remember if there's a police, I don't remember I don't know if that was any test. They did. They talked to Williams, and it wasn't developed at trial because it was considered hearsay for us to, because he was intending to call Williams at the time. But what we did ask, someone did ask Cummings, the detective, if they spoke to, the defense counsel did, I believe, and she said, did you talk to Williams? Yes. And as a result of that conversation, we made a photo array with Sean Meager. And they showed it to Luis Velasquez, who identified him and said he did not see him that weekend. Velasquez worked for Williams in the body shop.
He worked for the victim.
No, he worked for Williams, who owned Lou's Exhaust next door to the victim's house.
That's not where, okay, it's not the auto body shop.
It's Lou's Exhaust, Auto
Okay.
and Exhaust. Wow, and the victim has a different, he has a car detailing
Okay.
business, not at his house, it's
Yeah, okay.
elsewhere in Brockton. So, yeah, I believe with all of the timing, the video cameras, the constant description of the defendant as tall, skinny, wearing a Carhartt jacket, and then the jacket's gone. And, we had videotapes of his interviews with the police. We had video surveillance of a great deal of the activity around the murder and a very tight timeline. There were a lot of people around.
I thought the jacket's in the tub, right? I
It
mean,
was
it's in the storage thing at the boat, right?
There was not a different Carhartt jacket in the storage thing in the boat. It was an old one that had been there for like 6 months, exposed to the elements. Randall said that didn't look like the jacket he gave the defendant. The one he gave to the defendant had caulking stains on it.
Did they ever find that one?
I don't think they did.
No.
So the jacket's gone, and he'd always worn it. His boss testified, I gave it to him in the fall, and he always wore it. Bob said he always wore it. Always wore the same thing, hooded sweatshirt, Carhartt jacket, baseball cap. And now he's dressing differently, white sneakers, clean shaven for the interview. So he went from no money to 3-inch wad of cash, buying a cell phone and renting a hotel room for 3 days. So he's, inferably he wants to get out of Brockton. That would be our argument. And he paid $109 a night for 3 nights and incidentals, so it was like $300-ish. So it's our contention that Judge Chin properly resolved this case, properly denied the motions for new trial, and that there's just no error here that would have influenced the jury's conclusion.
Okay, thank you.
Thank you.